Hi, thanks so much for joining us on the final day of NamesCon Online. Here on stage 2, where we are going full speed ahead and have a brilliant program lined up for you today. You have made it to the best stage of the event. JT definitely heard from a little birdie that there's a dispute about that. So here on the best stage of the event, we are so excited to have you here. My name is Elizabeth Kluckart, and I am the Chief of Staff at I2 Coalition. We are the voice for businesses that build the internet. We help educate lawmakers and influencers about internet infrastructure and are advocates for policies that support internet growth and innovation. So if you have any questions, feel free to connect with me at the attendee section on the platform. And before we kick off the day here on stage 2, we want to give a big thank you to our streaming partner, Dan.com. This literally would not be possible this week without them. Another quick housekeeping reminder, if you want to have the holistic experience of NamesCon, you want to make sure that you are checking out the chat, the networking lounge, the social wall, partner booths, and the workshop rooms. Those workshop rooms, you will find our speakers to answer any other questions that you may not have been able to ask in the section, and they are super excited to have you there and engage with them. Okay. So not sure how many Law and Order fans we have out there, but I am super excited for this first session. No matter where you are in the world, what time it is, grab some popcorn and your preferred beverage, depending on your time zone, and you are in for a treat. We are bringing you Domain Court, arguing a real-life UDRP case. We have a room full of actual domain name lawyers, trademark lawyers, and UDRP panelists discussing a real high-profile case. So we're going to let them kick that off and have our moment in court.
Hello, everyone. My name is Kamila Simkiewicz, and I am the Executive Director of the Internet Commerce Association, or the ICA. Joining me here today are Zach Moskowitz, ICA's General Counsel, and Laurie Schulman, who's the Senior Director of Internet Policy at the International Trademark Association, or the INTA. The ICA and the INTA teamed up, and it gives us tremendous pleasure to welcome you all here today to a one-of-a-kind, never-been-done-before session. You're in for a treat as you get to witness firsthand what happens behind the scenes of a UDRP hearing. And we assembled a tremendous team here for you today. We have George Nahid-Chovansky, who will be the complainant's counsel, Karen Bernstein, who is the respondent's counsel, and 3 UDRP panelists who will deliberate and deliver a decision. Francine Tan, who will be the chair, along with Gerald Levine and Stephen Levy. I would like to thank all the participants for their time and participation. I would also like to thank the NamesCon team for hosting us and providing a platform to share this hearing with you. You can follow the facts of the case by accessing a fact sheet, and it will be provided here in a chat window and also in the session's agenda. The hearing will be followed by a Q&A session, so please stay tuned after the session and follow us to the Q&A room. And now you'll hear from Zach Moskowitz, ICA's General Counsel.
Thank you, Camila. As an INTA member, as General Counsel of the ICA, and as UDRP Counsel for the last 22 years, I am thrilled to co-present with INTA the very first ever in-person UDRP hearing as part of NamesCon Online. I'd like to thank the dream team of participants, and especially INTA's Laurie Schulman, for her imagination and determination in co-presenting this innovative event. The objective of this presentation is to educate stakeholders about the UDRP. The UDRP has proven to be a very effective tool to resolve domain name disputes since 1999, when it was first implemented by ICANN. Yet the very nature of the proceedings remains mysterious to many, because every one of the nearly 80,000 disputes to date have been resolved through written submissions and private deliberations only. But for the very first time today, in this moot hearing, the party representatives will make their presentations using oral argument, and the panel will deliberate in public, and the panel can directly question the party representatives. This moot hearing will highlight the tricky issues of ambiguous evidence and competing interpretations that panels are at times called upon to resolve under the policy. Many thanks again to the council and to the panelists for their participation, and please enjoy this unique presentation as much as I will.
And now Laurie Schulman, the Senior Director of Internet Policy at INTA.
Thank you, Camilla and Zach, for that wonderful introduction. I'm very excited to be here. Sometimes, as many people know, domain investors and brand owners find themselves on opposite sides of proceedings. Even when we are on opposite sides, we understand that the UDRP has evolved into a reliable forum for resolving disputes without expensive court battles. Over the years, the panelists have worked hard to reflect the actual state of the law and the growing understanding of the role of domain names within the internet infrastructure and global commerce. The UDRP is scheduled for review under ICANN's bylaws within the coming year, and we hope to work together to preserve what works and to maintain the spirit of cooperation and collegiality that has developed among UDRP panelists and practitioners, as demonstrated today by this mock trial event. Thank you again to ICA, to the NamesCon team, for allowing INTA to participate in such a fun and worthwhile project such as this one. Now on to the hearing.
And we are now going to go live to the first virtual UDRP hearing, where Francine Tan will call the hearing to order.
Thank you, Camilla, for the introduction. And with that, the session of the UDRP Moot Court will now come to order. May I invite George, the counsel for the complainant, to commence with his oral arguments. Thank you.
Thank you. Am I on? May it please the panel, my name is George Nahichavansky, and I represent complainant Red Ball Licensing in this proceeding. Now, I'd like to take this opportunity to walk the panel briefly through each of the elements of paragraph 4A of the policy to explain why the panel should rule in favor of complainant and transfer the domain name redball.com to the complainant. Now, to begin, the substantial documentary evidence we have submitted not only establishes that complainant enjoys strong rights in the Red Ball trademark in connection with its energy drinks, but that such rights arose well before the disputed domain name was registered by respondent. Complainant started using the Red Ball mark in Thailand in 2003, and by 2006, it was already selling over 2 million bottles a year in Thailand and extensively promoting the Red Ball product through sponsorships, celebrity endorsements, television commercials, and print articles, some of which reached consumers outside of Thailand, including the United States and Europe. Then in 2007, it was publicly announced that complainant had a manufacturing and distribution deal with companies in Atlanta and Vienna for the distribution of Red Ball energy drinks in the US and Europe. And by the end of the first 6 months of 2010, complainant had already sold 300,000 bottles of Red Ball in the United States. And by November 1, 2010, Red Ball was being sold throughout the United States and Europe. It's also worth noting that there was much promotion of Red Ball in the United States by mid-2020, including through a sponsorship of the North American Pickleball that was aired nationally through ESPN and through numerous state fair events that had Red Ball tents where Red Ball could be sampled by consumers, including in Iowa, where respondent is based and incorporated. Now, the growth of Red Ball has been astronomical since mid-2010, with annual sales in North America, primarily in the United States, reaching 50 million by 2015, and in Europe, 10 million euros. Worldwide, currently, annual worldwide sales of Red Ball stand at $600 million a year, and to date, there's been over $30 million spent on marketing, advertising, and sponsorships for Red Ball since 2003. Now, complainant has also promoted its Red Ball energy drink since 2006 through its website at drinkredball.com and through a number of CCTLDs. And Importantly, complainant owns multiple trademark registrations for Red Bull, including in Thailand, which issued the registration in 2007, and in the United States, which although issued in 2011, was filed in February 2010 with a first use date of February 3, 2010. And currently, complainant owns 67 registrations for the Red Bull mark around the world. Now, I don't believe there's any dispute that the domain name is confusingly similar to complainant's Red Bull mark, as it fully and solely consists of the Red Bull mark with the non-distinguishing .com GTLD. So complainant prevails on this first element. With respect to the second element, respondent cannot establish that it has rights or legitimate interests in the redbull.com domain name. First, respondent is not commonly known by the domain name and is not using the domain name for any website or web page. What is the core issue here is whether respondents buying an attempt to sell and monetize a domain name that corresponds to a well-known mark is legitimate under the facts before the panel. Now, just to be clear, complainant's not contesting that respondent might have a legitimate business in buying and selling domain names based on common terms. But that is not what is at issue here, although respondent will likely claim otherwise. In this matter, we are not talking about an instance of investing in a domain name for its value as a potentially descriptive term, but a clear attempt to profit from the trademark value of the domain name as associated with the well-known Red Bull energy drink. The substantial evidence, which I've already gone through, shows that Red Bull was already a well-known energy drink with an astronomical growth trajectory when respondent acquired the domain name in December 2010. Respondent's own actions clearly show that respondent acquired the domain name based on its trademark value in order to make a quick profit, or at the very least, respondent anticipated that Red Bull would become a significant brand based on its current trajectory in 2010, and that respondent could then sell the domain name for a sizable profit. Respondent bought the domain name for $80,000, which is significant, as the amount is almost as high as any other domain name ever sold by respondent. Now, where did that value come from? That value did not come from the prior owner of the domain name, who owned it for 10 years and merely used it as a redirect to another website, then went out of business, and then let the domain name lapse. The value likewise did not come from other alleged companies using Red Bull for other goods and services. The few that existed when respondent required the domain name in 2010 were minor and not well-known entities. The value came from the fact that complainant's Red Bull energy drink enjoyed much popularity and exposure by December 2010 and was an exponentially growing brand in the United States, Europe, and Thailand. And indeed, a simple Google search or search of the United States Patent and Trademark Office records for Red Bull would have quickly revealed complainant's extensive rights in Red Bull and thus the trademark value of the domain name. But real proof that the respondent bought the domain name to quickly profit from its trademark value is established by respondent's immediate actions after acquiring the domain name. Respondent, within days, listed the domain name for sale as a premium domain name for $500,000, an amount that was twice as much as any other domain name ever offered for sale by respondent, and 5 times as much as any other color formative domain name respondent has ever sold. And I believe that was redbird.com for $100,000. Respondent also allowed the domain name to be used if a website full of pay-per-click links 1 week after the domain name was acquired. One link was for Gatorade, a competitor of Red Bull, and another for links related to Thailand. As it turns out, respondent had a deal with the PPC provider to share PPC revenue. Those links continue to this day. Now, since 2010, respondent has continued to seek to profit from the domain name. In 2015, respondent used a broker to try to sell the domain name for $500,000 to 5 different parties. Now, before contacting the parties, however, it's interesting, respondent took steps to clean some things up and used the PPC provider's interface to specifically block links that use the keywords red, ball, energy, and drink. Clearly, respondent knew about complainant and was thinking about complainant and not some other red ball. None of the parties contacted were willing to pay $500,000. Now, respondent's broker apparently contacted a former marketing director of complainant to sell the domain name for $500,000, but that individual declined to purchase the domain name for that amount. There is no evidence that anyone else at complainant or its upper management or the legal department was ever contacted about the domain name or ever knew about this single attempt to sell the domain name. But notwithstanding the fact that respondent could not sell the domain name for $500,000 to anyone, the domain name by itself has remained at $500,000 since 2010. Respondent has never changed its price point and has indicated and made it clear in 2001 when contacted about the domain name that it would be worth that amount to quote the right company. Now, given that no one was willing to pay close to $500,000, suggests that it's more likely than not that in respondent's mind, the right company for the $500,000 price tag has always been complainant, a company that now has annual sales of over $600 million a year. We thus maintain that complainant prevails under the second element. As to the third element, the evidence shows respondent has registered and used the domain name in bad faith. As already discussed, complainant had established rights and reputation in the Red Ball trademark well before respondent acquired the domain name in December 2010. Respondent was more than likely aware of the Red Ball trademark and energy drink when she acquired the domain name at that time. Complainant was a publicly known company to be and known to be one of the fastest growing companies in Thailand. And since 2007, it was known that complainant had distribution deals in the US and Europe. The Red Ball brand was being heavily promoted in 2010, not just in Thailand, but internationally, including the United States, through various sponsorships and promotional campaigns. And in the United States specifically, the Red Ball energy drink was being sold in the US since February 2010, and was being substantially promoted by mid-2010 nationally. Indeed, there were promotions in the very state in which respondent is located and incorporated in, namely Iowa. At the very least, this is a case of willful blindness. As a simple search on Google or the USPTO records, or even the WIPO global brand database that respondent appears to be familiar with, would have shown complainant's existing rights in Red Ball. The fact that respondent jumped on the domain name for $80,000 and within days offered it for sale for $500,000 suggests that respondent was fully aware of its value, not based on a so-called common word meaning or combination, but on account of its trademark value as associated with complainant's Red Ball trademark. At the very least, respondent's immediate $500,000 pricing shows it anticipated the substantial growth of the Red Ball brand and seized upon that in the hopes that complainant would eventually want the domain name and pay a large premium for it, which would explain why the price has always remained at $500,000 from day one. Attempts to claim otherwise by respondent will ring hollow. The fact that there may be other uses of Red Ball in expressions or for other goods and services does not detract from the point that the value of the redball.com domain name is associated with its trademark value. At all relevant times, complainant's Red Ball has been the most well-known product using Red Ball. These other entities and uses are small, not well-known, post-date in most instances the acquisition of the domain name by respondent, and certainly do not drive the value of the domain name to $500,000. Indeed, in 2021, respondent responded to an inquiry that the price of the domain name was $500,000 and made clear that it would be worth it to the right company. That right company, more likely than not, could only have been complainant under the evidence presented. Lastly, respondent's bad faith is further established by its continued efforts to try and exploit the trademark value of the Red Ball mark that is associated with a domain name through PPC links. And what is interesting is that respondent continues to do so despite receiving a demand letter from complainant's counsel, which respondent has never responded to. In sum, for all of the foregoing reasons, complainant believes that it is entitled to the relief it has requested. Thank you.
Thank you, George, for that presentation. And may I now invite Karen to present arguments for the respondent. Thank you, Karen.
Thank you. My name is Karen Bernstein. I'm the attorney for the respondent, Connie Domanis. Respondent concedes that the domain name is confusingly similar and that complainant has standing to bring this UDRP. But complainant fails to prove legitimate use and bad faith registration in this panel and should be held to have abused these proceedings and respectfully requests a finding of reverse domain name hijacking. A little background about respondent. Respondent Domanis has been investing in domain names for 20 years with her company, LLC. She trades in generic, descriptive, acronym, and otherwise non-infringing domain names and owns over 20,000 domain names in her portfolio, many of which are color formative. Over the 20 years that Domanis has been investing in domain names, her business model has been to register color formative domain names like greenballoons.com, rednet.com, purpleclover.com, and yellowsnow.com years before registering redball.com. And then she typically creates a logo for them, parks them, and offers them for sale on salenick.com. Respondent also has a history of selling domain names above the price that they're purchased for, such as goldentrophy.com for $15,000 and redbird.com for $100,000. Accordingly, investing in domain names and offering generic, descriptive, if not descriptive, domain names for sale is a legitimate use. Respondent has not targeted the complainant. Complainant's red ball mark is not unique. Respondent registered the domain name for its intrinsic value, like she has for many other domain names that she's invested in. The domain name is a non-distinctive mark that has multiple meanings. Complainant cannot claim exclusive rights to the words red and ball. There's nothing unique about them. The mark consists of red ball, and red ball has multiple meanings, which is what attracted my client to invest in the domain name in the first place. Indeed, in Thailand, for example, it is commonly referred to as a local Thai fruit resembling red cherries for flavoring, and complainant attempted to file a trademark application in Thailand for red ball, which was refused based on it being descriptive. And also Wikipedia entries to find red ball for a high-profile police case. And also the object that is neither player's cue ball in a game of carom billiards, among others. Red ball is also a surname, according to Ancestry.com, and it's also a town in Belgium. Indeed, Taggart, who was complainant's, Taggart, who was respondent's sales rep, when they approached a complainant to buy the domain name in, clearly said to them that it was one of many companies worldwide that might be interested in acquiring the domain name. So, for example, there were several red ball trademarks that were obtained before complainant ever got its federal U.S. trademark registration. Mr. Taggart also contacted 4 other Red Ball trademark owners, but unfortunately they wouldn't pay the purchase price. They were in startup mode at that time. Respondent bought the descriptive generic redball.com for $80,000 at auction. And that was previously owned by a sporting good company to forward its main website. $80,000 for a domain name is not something a cyber squatter does. And it should be noted that that is a hefty price for a domain name. It certainly wasn't registered with complainant in mind. Respondent bought the domain name as she did as her usual business practice, and the $500,000 asking price was tied to the domain name's inherent descriptive value, based on the fact that there are so many other people or companies that own Red Ball trademarks. Certainly not targeting complainant, especially when she wrote back that the price for the domain name is $500,000 because it's worth it a lot more money, more than $5,000 to the right company. But that was years later. And besides, if you owned land in Hawaii, would you just sell it out for a lower price? My client felt that Red Ball was a very valuable, intrinsically valuable domain name, and she wasn't about to part with it for a measly $5,000. Complainant fails to prove bad faith registration and bad faith use. That's what complainant's burden is. And with respect to the bad faith registration, it would have been at the time that the respondent registered the domain name back in February of 2010. Nobody really knew who Red Ball was back in 2010. And despite complainant's assertion that respondent could have conducted a simple Google search, there is no proof that Red Ball, as in the complainant, was anywhere in the top results of Google in 2010. We have no evidence whatsoever that shows that. I also want to point out that complainant contends that there were celebrity endorsements of the brand, but there's no evidence that was put in about this. And I want to also say that a lot of the so-called evidence that complainant put in did not include unsolicited media attention. There are no articles in Sports Illustrated or any major media about their brand at that time, 11 years ago, 11 plus years ago. It was a long time ago. Let me also say that complainant claims that they sold 300,000 bottles of Red Ball in the first 6 months of 2010, and somehow that's supposed to be significant, which it's not. Because at the time in 2010, according to the US Census, there were over 300 million people who lived at that time in the United States. So if you do the math, 300,000 bottles is a measly 0.1% market penetration. And I don't think that that rises to the level of notoriety to show that somehow respondent knew about complainant. Let me also say that the ESPN broadcast of the pickleball event does not prove anything. Number one, pickleball wasn't even, maybe it was gaining some momentum at the time, but according to pickleguide.net, pickleball, the first national pickleball championship, was held in 2009. And even if it was on ESPN and complainant was the title sponsor, it's not specific to the broadcast itself. We don't see complainant submitting any Nielsen ratings for that broadcast. And let me just add that the respondent doesn't own a television. So how the respondent would have known about complainant based on an ESPN broadcast for some emerging sport is beyond me. Let me just know that when complainant fails to prove the bad faith registration and bad faith use, it knew when it brought this complaint to this tribunal that it didn't have any evidence to support the notoriety of the Red Ball brand at the time that the respondent registered the domain name. The sales data and the advertising spans many years. It doesn't pinpoint specific expenditures or sales in the United States. It refers to North American sales of $500 million. It cites all sorts of numbers, all of which occurred after 2010, after the respondent registered the domain name. So their sales data belies the fact that they brought this domain complaint, this UDRP, in bad faith. Because respondent never has heard of complainant until Mr. Taggart contacted complainant, and also doesn't live in Thailand, she had no idea who this company was until the time that Mr. Taggart offered the domain name in 2015. It's not bad faith to offer a bad faith registration or use to offer a descriptive domain name for sale that has multiple possible uses. And indeed, my client did search the WIPO Global Brand Database as well as Google before registering the domain name back in 2010. The WIPO Global Brand Database showed hundreds of trademarks registered by third parties for all manner of goods and services all over the world, and many companies have Red Ball formative websites with domain names registered both before and long after the registration of redball.com. There's a Red Ball, which is a U.S. registration. There's a Red Ball Logistics in Spain, for example. It's certainly not going to prove the complainant's case here. The respondent does not use the domain name to capitalize on complaint or to disrupt complainant's business. Although there were PPC links showed on redball.com, they were computer generated by SailNick, and none of them contained ads for complainant. One ad for Gatorade is not enough to say that the PPC links were specifically targeting complainant and trying to drive traffic away from their website. The complainant, it is pure and simple that the complainant abused these administrative proceedings. The complainant inquiring about Red Ball back in 2021, just recently, and then not liking the asking price is only to go to a UDRP was a Plan B move that rises to the level of reverse domain hijacking in general. Complainant knew it shouldn't have brought this UDRP. It must have also known about the other companies using the term Red Ball before it did. Specifically, complainant must have visited redball.com back in 2006 and knew that it couldn't get the domain name because of the sporting goods company and instead settled for drinkredball.com, which was long before complainants started entering into manufacturing agreements in Atlanta and Vienna, and certainly by the time it first started selling its drinks in the US in or around February 2010, which I might add, 25 states with a tent at a fair is not the entire country. And besides, my client didn't even go to the Iowa Fair, so that's very thin evidence from complainant's point of view. Complainant also knew about respondent by 2015 and did absolutely nothing. This is a case of laches. It has been 11 years, and complainant knew about the redball.com for at least 6 years, if not longer, based on the 2006 registration of Drink Red Ball, and did absolutely nothing. Indeed, its own marketing director in 2021 approached respondent to try and register the domain name, but did so on an anonymized email address without disclosing who they truly were. And this was the Plan B move. So, in sum, respondent respectfully requests that the domain name redball.com remain with it, and that this panel rules that the complainant abused these administrative proceedings. Thank you.
Thank you, Karen, for that presentation. And now the floor is back to you, George, for rebuttal arguments.
Thank you. So I want to briefly state a couple of, first of all, respondent is playing fast and loose with the facts. The first thing is that the domain name was acquired by respondent in December 2010, not in February 2010, as was stated. So if you go back again on the timeline, there's a lot of evidence that respondent says, oh, this, we didn't put in this, we didn't put in that. There's no proof that somebody saw it. She doesn't have a television set. These are all pretextual arguments that have been put together to basically mask the fact that respondent clearly knew about the Red Ball energy drink product, which not only was extremely popular in Thailand, and had been promoted extensively there and through in-flight magazines and other sources, but was promoted in the United States. And there were announcements about big distribution deals for Red Bull in the US and in Europe. And in fact, there were 300,000 bottles that were sold. And the standard is not, whether or not the mark has risen to whatever level that complainant, respondent wants to assert, but did we have trademark rights in it? And absolutely we did. And it was an exponentially growing brand. And it was a known brand in 2010 when respondent registered the domain name. But the thing that respondent keeps talking about is they weren't aware of complainant. They just didn't know anything about it. But what's curious is that they registered the domain name and within days immediately put it up for sale at $500,000. And if you look at that time frame, what was there, you see that there are some minor uses of Red Bull. There were not hundreds of trademark registrations that existed in 2010. In fact, if you were to look at it today, there are only dozens. And they're small and they're not, popular products. They're not popular services. And the only Red Bull mark that was out there that was really known was the Red Bull energy drink. And complainant seized on that, paid $80,000 more than anything that it's ever paid for. And they immediately set up to sell that domain name. And to believe that complainant didn't know, that respondent did not know about complainant is absurd. Because even if she didn't have a television, she's on the internet and she knows what's, she knows how to use the internet. And clearly, I probably could easily find that complainant was selling an energy drink that was growing and that grew from the 300,000 bottles in the first half of 2010 to a $50 million a year product in North America. So in all, I think that you can look at these facts and you can see that there has been specific targeting of complainant from day one. And in fact, it goes beyond just selling for $500,000 or trying to sell it for that amount, but using it for pay-per-clicks that they clearly knew were related to complainant. And lastly, with regard to this claim of reverse domain name hijacking, we do not believe this is warranted because we believe that complainant prevails in this matter. Thank you.
Thank you, George. And Karen, the rebuttal arguments from your side. Thank you.
I apologize about misstating that the domain name was registered in February of 2010, when indeed it was registered later, but that's of no import. First of all, Thailand is not the United States. The trademark registration in the US and elsewhere is simply on the first element of whether or not the complainant has standing and that the domain name is confusingly similar to the trademark, which respondent has conceded. The trademark rights that complainant points to, and trademarks are generally country by country when you're talking about the bad faith registration issue, is where is respondent located? My client is located in the United States. So there's no way that my client in the US would have known about any use of Red Bull in Thailand. As far as trademark rights, the complainant's trademark did not issue until 2011, which does revert to its filing date, which happens to be the same date as the first use date of February 10. So that doesn't really do complainant any good with respect to the state of mind of respondent at the time of the registration, not in 2015, not in 2021. What was the state of my client's mental state when they registered the domain name back in 2010? I believe it was in August. That complainant has failed to prove by preponderance of evidence. My client's business practice of putting up domain names after they're purchased onto the SailNIC website, as discussed previously, along with a logo and an asking price, is standard business practice for my client. There is nothing having nothing to do with the complainant. And as far as other companies involved, they were small companies in 2015 when respondent went to try and sell the domain names, and respondent also asserts that so was complainant in 2015. you don't know whether or not a company where you plant the seed in 2015 might get enough funding in the following years to be able to afford a very valuable domain name like Redball. And as far as complainant's assertion that respondent knew about complainant at the time of registration in August of 2010, despite the fact she doesn't have a television, that she uses the internet, we've already gone over the fact that complainant failed to prove any top results for Google at the time in 2010. Indeed, the sales data is that complainant submitted in support of its claim of notoriety at the time the domain name was registered in August of 2010 was aggregated data that didn't even pinpoint what media was used. And the fact of the matter is, without the underlying data, complainants' attempts to show that it had some sort of notoriety at that time of the domain name registration fails. We respectfully, once again, on behalf of respondent, respectfully request that this panel find that complainant has abused these proceedings as a reverse domain hijacking. Thank you.
Thank you, everyone. And now the panelists, Francine Tan, Steve Levy, and Gerald Levine will deliberate.
Thank you, Camila. Before I invite my fellow colleagues on to discuss the merits of the case, the issue of the standard of proof is one of a balance of probabilities and not one of beyond a reasonable doubt. And this means in very simple terms that the burden of proof is met by the complainant when the complainant is able to convince the panel that it's more probable than not that the facts that he alleged are justified and are supported by the evidence that was submitted. One thing that stands out for me in this case is, of course, the fact that we're talking about a dictionary term, and it's a dictionary term, and the issue then is, by virtue of that, is that sufficient? Is it that the case that by default, when we're talking about dictionary term, which has various meanings and connotations across different cultures even, it could be a different slang word, does it then mean that the respondent has by default a legitimate right or interest in the domain name? And in this case, I have to say that I'm inclined to say no, because the context here and the way, what stands out for me and what I have a problem with is the fact that the respondent has not shown how it is relying on the dictionary meaning of Redball in its registration of the domain name. Steve, do you have any views you would like to express on the second limb of the UDRP regarding rights and legitimate interests?
Well, it seems that there are some facts that do counsel on either side. As we said, this is a balance of probabilities. So we're simply, weighing which is a little bit more on the scales. On the one hand, the pay-per-click links, at least some of them did in fact relate to the complainant's business. But then in 2015, the respondent took some active steps to try and remove references to the complainant. You also had the respondent's broker reaching out to a number of different parties, not just the complainant. But I'm still a bit concerned about the price of the domain name. The fact that it was listed at such a multiple of the respondent's other domains, and in 2010, at the time that it was acquired. So the price is something that's weighing heavily on my mind. If it was saying $500,000, in 2015 or 2021, at the time that the complainant's brand had grown,
then it might look more like targeting. But the fact that it was $500,000 immediately after acquisition by the respondent is something that I am concerned about.
So if I were to ask for your decision on the second element, what would that be? Steve and Jerry, and then I'll say my view on the issue. Thank you.
Well, on the second element, as we've noted, hosting a pay-per-click site or offering a domain name for sale in the abstract are not illegitimate, and so I feel that as a domain investor, there is at least a legitimate interest in the domain name.
And Jerry?
Okay. So I have two senses in terms of how to proceed on this. First of all, given the totality of the evidence, I would agree with Steve that there is that the respondent has successfully rebutted the complainant's contention that it lacks rights or legitimate interests. This always depends on what the motivation is, and the complainant has really based its argument on a rising reputation, and yet that reputation is limited to in essence, to a niche market. It's not as though it hasn't risen, at least in 2010. It hasn't risen to the point where when you say Red Ball, you immediately think of Pepsi or Coke. It's not in that league. It may be in that league today, but it wasn't in that league in 2010. So the issue here is knowing this and understanding the research that was done here, where the respondent learned that there were many other registrants of that trademark, that doesn't demonstrate the kind of bad faith that's necessary for us to conclude that the registration was abusive. So I think on the third element that the complainant has not demonstrated that respondent either registered or is using the domain name in bad faith. Back to you, Francine.
Thank you. I'm going to keep my my comments really short. I mean, my view is on a balance. I'm inclined to find that the registration was made in bad faith and used in bad faith. Firstly, because of paragraph 4B, 1 of the UDRP says if there are circumstances indicating that the registrant or respondent had acquired the domain name and for the purpose of selling or otherwise transferring it to the complainant who owns the trademark for valuable consideration in excess of the documented out-of-pocket cost. So that's one thing. And also because I found a lack of rights and legitimate interests. And lastly, it's just a combination of factors, the timing and circumstances of the registration of the domain name and the high price, the very extraordinarily high price, which was put on this domain name, which suggests to me that the seasoned domainer understood the trademark value of Red Ball, even though Red Ball per se is a combination of two very ordinary words, but there was extreme value in this, just like Apple is a very ordinary word, but has a lot of value to that. So that's my comment. So thank you everyone for that very interesting discussion. And the The panel's decision will be presented in a live Q&A, and I therefore now call the hearing to a close. Thank you.
Thank you, everyone, for this interesting, informative session. I felt like I was really part of an actual hearing. So thank you, everyone, for your time. To the audience, please follow us to the live Q&A session to hear from the panelists.
All right, what an informative session here on stage 2. Head over to the Q&A room within the workshop area. And to benefit from all of the features of the platform for our next session on stage 2, starting at 4:45 UTC, click over into the join session button for our next panel.